So before we look at exactly how the YCJA deals with these different typical youth crimes and youth crime in general, I want to give you a little background about what had been done before now. And up until 1984 in Canada, the crimes committed by minors, which is, I mean, it was still, they didn't use the same language, but the concepts were very similar. Crimes committed by minors weren't dealt with really formally in the same way that crimes are dealt with for adults, in the sense that you get accused of something, you get charged, there may be a trial, right? Instead, they had the Juvenile Delinquency Act. And under the Juvenile Delinquency Act, the thinking was, again, well, you got to treat children differently from the way you treat adults, but it's because it's not thought that you need to treat children the same as adults. You figure, well, adults you would treat with by charge them, by putting them on trial, and so on. But youth, that doesn't make the same sense to deal with youth that way. So instead, you're going to deal with them as people who have problems, which is kind of like how we deal with people under the age of 12 who commit major crimes when that does happen. But under the Juvenile Delinquency Act, it really gave maybe too much latitude to judges. There was too much freedom for judges to not decide formally using formal evidence matters whether it was fair to say that somebody had committed a crime. Because what ended up happening is that judges tended to unconsciously apply their own social class prejudices in dealing with these cases. So that meant that if you don't have a trial, because you're saying, well, that's for adults, we don't want to be, criminalizing these kids too early, it meant that they didn't have the defenses in place that adults have. And it meant that they didn't have the ability to really challenge evidence that may have been a little false that was led against them. So if you brought a kid in front of the judge and the judge kind of looked at the kid and said, all right, I know what's going on here. Here, a shopkeeper who's 40 years old, tell me what this kid has done. And the shopkeeper says, well, this kid is always causing trouble. He's always stealing my comic books and my bubble gum. And, the kid might have a very different version of the story, that this adult may have been acting incorrectly as well. But since there wasn't the context of a trial, they didn't necessarily have a means to bring their concerns forward. And it was really just up to the judge to decide, all right, let's see what I can do here. And where that became a huge problem was if the child who was in front of the judge belonged to a class or a group or whatever it is that the judge would have pre-existing beliefs about. The focus was entirely on rehabilitation, which sounds good. But it can be a little bit tricky where if a judge decides, well, you know what, we're not going to focus so much on the crime you did this time, it's more on the path of life that you're showing. I'm going to focus on molding you into more the person I think you should be rather than just directly addressing your crime. You might remember vaguely earlier on in the year we were talking about this concept that C.S. Lewis put forward about 120 years ago, that if the law becomes too focused on rehabilitation, if that rehabilitative impulse isn't in any way limited, then it can run away and get a little crazy. Because if you're saying, all right, I'm just going to sentence someone for the thing they did. If they shoplifted and it's minor, I'm going to say, okay, well, the punishment's got to fit the crime. Maybe they'll get 30 days probation as a young person. It's going to be meaningful. You're going to have to write a letter of apology to the shopkeeper, whatever it is. But if the focus is entirely on rehabilitation and it's not a criminal system at all, then you might look at this kid and say, well, I know you happen to shoplift here, but let's see what the real problem is, and let's see what needs to be done to get you on the right path. Well, I don't think your parents are doing a very good job of raising you, so we're going to put you in the juvenile reformatory, and we're going to keep you there until you're completely rehabilitated. So it's not just that you won't be shoplifting anymore, but that you're going to be, in school the way we think you should be, and that your life is going to change from the way it is now, because obviously you're going down a bad path. Where this became a huge problem was when you were native. And in Canada, you ran into judges who weren't native dealing with kids who were native, and often sharing the same communities in situations where the judges might have prejudices about how the kid was living his life. And so even if the kid hadn't necessarily committed a major crime that would justify a lengthy period of being in a reformatory, the judge would decide, well, I know what's happening here. The only way to deal with this is to lock this kid up in a place where he's away from his parents and where he's going to get better influences on him. So these unconscious and not necessarily maliciously intended, but still very destructive prejudices that judges would translate into Native kids being kept in the reformatories for very long times, even when under a sentence that were supposed to match the crime, they wouldn't have spent very much time being punished at all. And since you weren't being prosecuted, even if you saw this happening, let's say you're a Native kid who's 15 years old, and you hear the judge and you know what the judge is thinking, and the judge talks about putting you in the reformatory, you don't have a lawyer in court because, again, this isn't seen as a criminal process. So those safeguards, procedural safeguards that protect adults, weren't there to protect kids, right? You understand the thinking was, well, let's not make it too criminal-like as a system. We don't want the kids to be criminalized. But it meant that their interests weren't always articulated, that there wasn't always somebody who could make sure that the law was looking out for their best interest, other than just hoping that the judge wasn't prejudiced or that the judge is going to do a great job. So this caused problems up until 1984, and people recognized the shortcomings with it. There were criticisms of it. So Parliament decided they needed to bring in something else. So they brought in what's called the Young Offenders Act in 1984. And this was meant to remedy some of the problems with it. So it was actually a criminal system. And in dealing with the problem of there being, especially Native kids in reformatories for very long periods of time, even if the crime they committed might not necessarily have been very serious, the Young Offenders Act set a maximum sentence of 3 years imprisonment. And this is really what made people very upset about the Young Offenders Act. Because the Young Offenders Act, that 3-year limit, was meant to respond to the problems of the Juvenile Delinquents Act. But what it meant was that when there were very egregious cases of youth committing very serious crimes, that 3-year maximum was in place. And this is what got people very upset. When I was in high school in 1995, there were 3 young people who, at the time they committed this murder, they were 14, and they murdered the Reverend Frank Toop and his wife in Beaconsfield. These 2 people were elderly. I think they were both above 70, possibly above 80. And these 3, idiots went into their house, and I believe they beat them to death with a baseball bat. It was a very, very grisly murder. There wasn't even really a good reason. Not that there could be a good reason, but I don't think they were even looking for something. It was just kind of a contest of stupidity where one had a dumb idea and the others wanted their ideas to be even dumber, and so it escalated to the point where they committed this horrific crime. And because the Young Offenders Act set a limit of 3 years, that's all they could be sentenced to. They were sentenced to 3 years in custody at the time, and people were very, very upset about this. And even though it's pretty rare that young people commit murders, since these murders were only getting punished with 3 years in custody, this is what caught people's attention. This is where the moral panic would set in. They say there's no, young people are running rampant. We have no protection from young criminals in society. Other cases prompted huge public backlash. For example, in 1999, there was a case of a 15-year-old named Jonathan Wambach, and you can watch on YouTube, you can watch the not very good movie about what happened to him. He was 15 years old, and he got in a conflict with a group of youths in his town of Newmarket, Ontario, at his school. And they found him, they ganged up on him, beat him up, to the point where he was in a coma for 3 months. He suffered permanent brain damage that he still suffers from today. And since they hadn't murdered him, they didn't even get the maximum penalty. They were convicted of aggravated assault, but their sentences were relatively light. They were less than 3 years for essentially putting this kid in a coma for 3 months. The Toronto police chief at the time managed to convince 1 million people in the Toronto community, because Newmarket's a suburb of Toronto, to sign a petition saying we've got to do something about the Young Offenders Act. It's woefully inadequate in dealing with youth crime. Kids are running rampant. They're a danger. And keep in mind, back in 1999, like a petition that gets 1 million signatures, that's actually 1 million, like in-person, on-paper signatures. This isn't something where you click a link on the internet. These are people actually lining up to sign this petition. And if you have a city of at the time about 4 million people and 1 million of them are signing the petition, that's a pretty loud voice saying we all hate this piece of legislation. Something's got to be done. And so the public hated the Young Offenders Act, even if they didn't entirely know that much about it. Judges also bought into this moral panic. They understood, well, the Young Offenders Act is pretty light-handed in dealing with youth crime, and so they kind of overcompensated in the sentences they gave. The sentences for youth under the Young Offenders Act, because of this overcompensation by judges, actually tended to be more severe in the amount of jail time kids would get for the same crimes that would be committed by adults. So if an adult would get maybe 3 months for it under the Young Offenders Act, because judges had this vision like, oh, the kids can do anything with impunity, I have to do something about this, they might sentence a kid who did the same thing to 5 months in jail, whereas an adult would only get 3. And what it generated was, even though we tend to compare incarceration rates in Canada to the United States, and we know that the Canadian incarceration rate for adults is significantly lower than the United States. It's only about 20% of what it is in the US. For young people, it was actually the reverse. And Canada had, at the time, the highest rate of youth incarceration in the Western world. No other country in the Western world put more kids in jail than Canada did under the Young Offenders Act. And it was perceived as light, but again, for emphasis, despite how light the public thought it was because of their moral panic, it was actually the case that Canada had the highest rate of youth incarceration in the Western world if you were a young person. You were more likely to be in jail as a young person in Canada than anywhere else in the world. And so this situation, which judges may not have been super aware of, Parliament finally got around to dealing with this problem of this concern that youth were just going crazy and doing violent things, and at the same time being incarcerated to such extreme levels that they decided something needed to be done about it.